You're welcome back. This is NewsFile. It's your most authoritative news analysis platform. And here on NewsFile, we put Ghana first. As I announced earlier, our next guest seated, Inusa Fuseni, is MP, Tamale Central, and Ranking Member, Legal, Constitutional, and Parliamentary Affairs. He honorably is bowing out of Parliament, so he's not contesting another time. Yawabing Asamoah, MP, Adenta, and Director of Communications of the New Patriotic Party. He just done one term, but he's being battled by 4 other people. It must be a difficult time for you now. This morning, you would have wished that you were in the constituency trying to protect your turf. I did. Right. It's all about service to God, country. But of course, your constituents are watching. I hope that your delegates are also watching, and they know that you have a double task as the communications director of the party.
I believe they appreciate that.
Yeah. They'll be kind to you, I suspect so.
Thank you.
All right. So on Zoom, we have Dr. Kojo Pumpuni Asante, Director, Advocacy and Policy Engagement at the Ghana Center for Democratic Development, CDD. We'll bring him to you immediately. We have him on the show. Right. So if we may start with, I hope we can start briefly on the asset declaration matter, and then we get him on, because we can deal with that very quickly and then spend the rest of the time on the Electoral Commission matter, which some people are fatigued about because we have been talking about it for a long time now. So on the question of the asset declaration issues, we know now that particularly one particular group, the ASEPA, or what is his name again, has decided to Alliance for Social Equity and Public Accountability, ASEPA, Alliance for Social Equity and Public Accountability, has decided to focus in this area to be checking on public officers whether they are declaring their assets or they are not doing so. The last time they filed a petition as charged, according to the law, they filed a petition as charged against the Chief Justice, and they said he had failed to declare his assets. Shraj did a finding and discovered that they filed their petition against the Chief Justice on a particular date. The date on which they filed the petition was the same date that the Chief Justice also submitted his asset declaration report, so to speak. Now, let me be clear about that. They had a complaint. The date on that complaint was the 16th of December. But they lodged that complaint on the 19th of December, 2019. That's the one against the Chief Justice. Now, the 19th of December is the date that Shraj received the petition. When Shraj did its investigations, he found that it was on the same date, the 19th of December, that the Chief Justice declared his assets. So they gave a ruling and said, unfortunate, the day you brought your petition is the same date that he had declared. So we cannot find for you that the Chief Justice has not declared his assets. Then the second one, which the ruling from Shraj just came, they took their petition to Shraj on the 12th day of December 2019. Shraj wrote to the Auditor General, which has the declared assets, is the custodian of it. Shraj wrote on the 17th of December asking the auditor to confirm if Jean Mensah has filed her assets. The Auditor General replied on the 30th of December that she had not filed her declaration. But later, it was found that she had filed her declaration on the 12th day of May 2020. Yes, on the 17th day of February 2020. 17th day of February 2020. So in that regard also, Shraj's ruling is that she has filed. She has filed late, but she has filed. All of them, it doesn't matter how late they file, there's no sanction for them. Now, these MPs are in Parliament looking at the asset declaration regime and what they can do about the law. The question we are asking today is, what else can be done? Kojo Pumpuni Asante joins us now. Thank you very much for joining us, Kojo.
Thank you. Good morning to the two honorables there, as two of my favorite honorables.
Right. Let me start with you, Dr. Kojo Asante. The outcome of the two decisions by Shraj, how do you take it?
Yes, well, thank you. Let me just make some preliminary comments before I deal with your substantive question. I think we have a problem in terms of how we are pursuing our accountability and anti-corruption agenda. Currently, as I have observed and followed very keenly, we seem to have really weakened the whole horizontal accountability structure of our anti-corruption agenda. So typically in a democracy, you would expect that the preventative side, which involves everything from internal audits, procurement supervision, asset declaration, information disclosures, and so on, which is all meant to ensure that there is integrity in public life, that the taxpayers' money is protected, have all really been weakened. And it's because the law that governs these processes are weak, both in terms of some of its design and then, of course, its enforcement, because there's too much discretion around some of those processes. So the Shraj examples you give, for example, the Constitution is very clear that you have to declare your assets before you take office. So it says before you take office. And then it says every 4 years. And then when you exit office. So I don't see the ambiguity there. And therefore, if a matter is brought and Shraj has to make a determination in terms of what kind of remedial action it has to take, I think you cannot say that, well, in spite of the Constitution, the person has still complied with the law. I think you can say, okay, yes, the person has breached the law, but this is, what we recommend. We just a slap on the wrist, don't do it again, or something like that. That's a different kind of decision. But it's also because Shraj has not elaborated through a CI the range of sanctions that should apply in some of these cases. And in some of these cases, it's not just an administrative sanction that will suffice. So suspension, demotion, other types of sanctions that you can apply, sometimes criminal. If you look at the Kenyan Public Ethics Act, for instance, the only offense that is elevated to criminal status with asset declaration is failure to declare your assets and falsely declaring. So if you intentionally do it, then that is fraud. So there are a range of things that can happen, but since the promulgation of the 1992 Constitution, Shraj is yet to elaborate on these sanctions. And as a result, it's left to discretion on what it should do today. And that does not promote equality before the law. It does not promote any deterrence effect or prevention of corrupt acts or any acts that are seen as misbehavior in the public service.
So, in Shraj's rulings, you would find Shraj often giving the purpose for the law. And in one of the decisions, Shraj said, it is for the promotion of transparency, public accountability, culture of integrity. The law, as you have looked at from the Constitution, must also be looked at from the Act itself. The Act says, an officer required to declare his assets and liabilities under this Act, who, without reasonable excuse, fails to declare, or knowingly makes a false declaration, contravenes that part of the law. So it means, therefore, from what Shraj has done over the period, particularly in these two cases we are using as examples, the people, the Chief Justice, may have filed late, but with reasonable excuse. The Shraj EC boss may have filed far late, but with reasonable excuse. So the law allows a situation where even if you don't file it before you assume the office, you can be excused. Is that not so?
Well, but it's still, the problem still remains. It goes back to the whole problem of unregulated discretion. So, as you say, you use the word may, because you are not apprised with the circumstances under which this particular conduct was excused. And if it was excused for the Chief Justice, was it excused for the accountant at the Ghana Publishing Authority, or is it because it's the Chief Justice, or it's an EC chair?
A reason was given that these are very busy people. Someone like the Chief Justice is a very busy person. So if, he's unable to file at a certain point, you may not read deliberateness into it. The chairperson of the Electoral Commission is super busy. If they are unable to file it before they assumed office, you may not say it is deliberate. In any case, by the time the complaint is filed, by the time the complaint is determined, they have already gone to file it to show that it's not as if they are running away from anything.
Well, also, that would be unfortunate interpretation of both the public policy and the principle under which a whole chapter of the Constitution is dedicated to ensure a certain proper conduct of public officers. Because we are talking about, the protection of the public interest. These are very, very powerful people. They take very powerful decisions. Their decisions, if it's not in pursuit of the public interest, but for public personal gain, it will cost the public. The president is a very, very busy person, but he still has to go and swear an oath. He has to sign all manner of documentation, which if he does not, he would have breached, the oath of his office. So that cannot be an excuse. This is a regime all over the world that is to safeguard both the integrity of that public officer, but to ensure that those who make themselves available to serve the public actually pursue the public interest. So I cannot, if that is an explanation, that because when Shraj actually makes these pronouncements, it becomes law in essence. So somebody can come and say, I'm too busy. I'm very, very busy. I'm the chief of defense staff. I am very, very busy. So relatively, it's a level of busyness would excuse you from your duty. I don't think the framers of the Constitution under Chapter 24 ever conceived that could be a basis for refusing to to do this. So I am hoping that this discretion is regulated through the act that the Conduct of Public Officers Bill, to make it very clear what kinds of circumstances and issues can be justified if to guide the supervisor of this regime.
So you hold
Otherwise,
on there. You hold on there.
It'll be abused.
Yeah, I will return to you so that we can look at what improvement from this experience can be made to the law as is being considered now by Parliament, and view it also from the recommendations that Shraj has made in both decisions that we are using now, the recommendations that it makes. Because the law says when Shraj does the investigations, it may take such action as it considers appropriate in respect of the results of the investigations, or if he didn't have to make an investigation, but whoever the complaint is against admitted when the complaint was filed that yes, we have not been able to comply. In these two examples, nobody admitted that they have not been able to file, except that it was discovered on the facts that they did it late. And in the issue of the EC chairperson, it was far late. Now, so, Abu News Officer,
yes,
Shraj says the chapter of the Constitution, that's 24, right, on which this regime comes is Code of Ethics, Code of Conduct. So they take the view that if it is just Code of Conduct, whilst the conduct may lead to criminal sanctions or something else, the punishment often is not as if there is an intention to punish you. So in these circumstances, the decisions they have taken, it should be deemed as fair. Not to have, they haven't done anything to them. They just gave a caution that you have done it late. Don't do it next time. It's not nice.
Well, Samson, I think it is proper for me to extend my sincere felicitations to you because it's a long time.
That's right.
The last time was when you were downstairs.
That's true.
And to wish my brother Bobina Samoa well in the impending primaries. I know he's facing stiff competition in his constituency.
Okay.
Samson, you quoted exactly from the decision of Siraj in the Alliance for Social Equity and Public Accountability against Mrs. Jean Adukwe Mensah, in which you said the purpose of chapter 24 of the Constitution is to engender, encourage high sense of integrity, engender political or public accountability. Now, Article 24 of the Constitution is part of the chapters of the Constitution and starts from Article 284 to 287, or 288, because the interpretation is part of it. Now, the provisions of the Constitution, it has been held in many cases, are justiciable. And it's important when you...
Provisions of the Constitution are justiciable, meaning what?
You can go to court to enforce them.
Okay.
You can go to court to enforce them.
All right.
And so when an anti-corruption body bemoans its capacity to enforce provisions of the Constitution that frown upon an act or an omission which is in contravention of the Constitution, then you have a problem. Because the Constitution tells us in Article 2, which is enforcement of the Constitution, a person who alleges that any act or omission of any person is inconsistent with or is in contravention of a provision of this Constitution may bring an action in the Supreme Court for a declaration to that effect. Clear. In the case of Articles 284 to 287 that deals with the conduct of public offices, if the contravention is in relation to any public officer, the jurisdiction of the Commissioner of Shraj is invoked. If the contravention deals with the Commissioner himself, it's related to acts or omission of the Commissioner because of the time-tested maxim in law that you can't be a judge in your own cause, the contravention will be a subject matter of investigation by the Chief Justice. So if the Chief Justice is accused of contravening the provisions of the Constitution, it is the Commissioner who investigates him. And if it is the Commissioner, it is the Chief Justice who investigates him. So when I see in a report of Siraj, in the case numbers CHRAJ 357 2009, in which Siraj admits that at the time that the petitioners filed their complaint with them, up to the time that they wrote to the Auditor General for verification as to whether or not the Commissioner had complied, the results were negative. The Commissioner, the Siraj establishes without doubt that the Commissioner was in default of compliance to the provisions of the Constitution. It beats my imagination how a commission can come to the conclusion that the Commissioner is in default, and at the end of his decision comments the Commissioner. You see why our anti-corruption fight is having difficulties. It's having difficulties because it appears to me.
I don't remember the commendation.
Oh, it's here.
Yes, show us the commendation. But
the commission commends the complainant for discharging its civic duty.
Yes, so it's a complainant.
Wait. But when they're shivering, you don't go ahead. By helping to hold public officers accountable, the commission equally commends the respondent for her cooperation. Cooperation in what?
Cooperation in the process.
What process?
No, they are setting people that when complaints are filed against them, their attitude to the complaint filed against them, it's either belligerent, non-cooperation. But in this case, she was cooperative.
What was the cooperation?
And they commend her for the cooperation.
What was
they don't commend her for filing her declaration.
Samson, as I'm leaving Parliament, and I hope to be part of the people who will be deepening the jurisprudence and the effects of law on public servants in this country. Samson, if a complaint is brought against a public officer and the public officer files
a response
or answer, and in this particular case, what Jim Mensah simply did was to go to the Auditor General's office on the 17th day of February 2020 and file her declaration. More than 1.5 years after she had been appointed Electoral Commissioner.
She was appointed on the 1st of August 2018.
And she filed on the 17th of February 2020, more than 1.5 years.
And the law's requirement is that you must file before you assume office.
And if you go by the Act, in any case, not beyond 6 months.
Not beyond 6 months. It's applicable to when you exit office.
No.
Is that not so?
No. If you go by the act, I mean, I have a difficulty with the act, but let's go by the act. If you even go by the act, it says in any case, not beyond 6 months.
All right.
So says that, and that is Act 550, Section 1, or Section 1, subsection 3. It shall be the responsibility of officers required to make the declaration under this act to obtain the forms from the office of the Auditor General. 4. The declaration shall be made by the public officer A before taking office, B at the end of every 4 years, and C at the end of the term of his office, and shall in any event be submitted not later than 6 months of the occurrence of any of the events specified in the subsection.
Right. So you have
even if you
opportunity.
assume office and you are unable to do it before assuming office, in any case, don't do it. Do it within 6 months.
6 months.
She did it 1.5 years, 1 year, 6 months after she was appointed into office.
But the
and
law
you still
also
commend
says
her for doing that.
Commend her for the cooperation.
What cooperation?
In the investigation.
What cooperation was that?
There are people when they serve them the complaint.
They say they won't file.
They will find all legal means. They will even take Shiraj to court. They will do all sorts of things.
Have you heard of any such thing?
Oh, it has happened always. It always does.
No. Shiraj will always investigate, and people have basis to challenge the decision, but not cooperation. People always cooperate with Shiraj, but they challenge. So you see the data bank.
The 6 months window. If you fail to do it before you assume office, the 6 months window, is it not your understanding that according to the law, failure with reasonable excuse is allowed? If you have made a false declaration and it is found that the false declaration was made unknowingly, that one too is allowed.
Yeah, because the law uses, law fixes specific intent on persons who declare.
Yeah.
So knowingly.
So in this case,
so if you declare and it's false, you need to prove that you knowingly did that.
Right.
So I don't have a problem
so
with that.
in this case, is it your contention that where you can be excused, even if you had a reasonable excuse, or even if the declaration was false but unknowing, all of that must be within the 6 months.
All of that must be within the 6 months.
Oh, okay.
All of that must be within the 6 months. First of all, the law provides that before assuming office, so the 6 months is just a waiver for you in the event that you are unable to do it within 6 months. The law says, and it's a mandatory provision, shall comply with the provision within 6 months.
Right. Let's hear Yawabwadenya Samuel. And we're using these two examples because they are the only ones that exist now for us to, and they are the most recent of the CJ.
But I thought I should have concluded.
Okay.
So I'm just saying that, look, Shiraj, yes, it's true. Article 287 is not expansive enough. Does not show exactly what they do, what they should do. But you see, any action appropriate, read together with Article 2 of the Constitution, where there is an obvious breach of the Constitution, will definitely have a remedy.
Okay.
The commissioner can go to court for a declaration that that public officer has breached the provisions of the Constitution.
Okay.
And then ask for consequential reliefs. You see, we must expand the frontiers of our jurisprudence. You don't just sit back and say that because the provision appears not to give me the tools to deal with public officers.
Or it doesn't define the things I should do, even though it gives you discretion.
Discretion.
It says you will take the action that you find appropriate.
And then you interpret that discretion to mean you can only issue administrative sanctions. That is where the lacuna is. That is where the weakness is.
I'll return to ask you whether Shroud cannot give them fines and say pay X amount of money or do so and so because you have breached it. But if you read the act, it says failure to declare or knowingly making false declaration shall be a contravention. That's in the Constitution. Shall be a contravention of this Constitution,
yes,
and shall be dealt with in accordance with Article 287, which you referred to earlier. All right. Yes. What do you say?
Since the last time I saw you, your hair is rapidly growing.
Yes.
You are thinking too much.
Yes. No, since January, I decided to leave it on.
Is that so?
Yes.
Wow. Today's topic reminds me of Friends of the Truth and Enemies of Lies. Do you remember?
I do.
You remember the things that happened? Friends of the Truth, Enemies of Lies. Who is right? But essentially, what we are dealing with is critical because the state, and in particular in countries like ours, fledgling democracies which are growing, the state happens to be the center of wealth. The state is the one that husbands our wealth and literally distributes it. And therefore, inherent in that function is the notion of favoritism, nepotism, corruption, and all those things. So our perpetual search for effective means of ensuring that fairness will be employed in managing our commonwealth. Now, that concern we haven't dealt with effectively up to now. But I disagree with Kojo, Dr. Kojo Asante, when he says that we are weakening. Because we are not weakening, it's not there. We are actually building, but it's not strengthening fast enough. It's not as if we had an effective structure that we are degrading or downgrading as we go forward. The structure has not been effective. And I'll tell you why immediately. Look at the Asset Declaration Act 550. Something. Our concern over the years, we all know it's not been effective, is that, and I was with GI, we've been debating and looking, I think, at the wrong place before the right place. We thought a lack of publication was the problem. And that if we were to publish it, people would. But then there was a tension between publication and reach.
The advocacy has been for two things:
Publication,
verification and publication.
Yeah.
Because the Auditor General receives it, but it doesn't have power to verify that what you have brought, in fact, if the envelope actually contains anything or just an empty paper.
Exactly. What I'm saying, the publication was supposed to take care of verification.
Okay.
We were looking for verification within publication.
You're right.
So the question has been about how do you determine whether it has been filed and it is true? You publish it for everybody to know. How do you verify? People who know the person must be able to tell the world that this is true or false. So that tension has been there. Both tension and reach, that suppose the person were to hide it with a relative, a wife, a sister, a brother. How do you get there? So then there was a question of how far you also go, spouse and all that. These two things, the people who have argued against them have said that in our cultural milieu, if you publish, you are inviting damage, literally, onto the person's capacity to even flourish as a person in society, because the entire extended family will descend on you. That's the positive side. The negative side is that you attract criminal activity to your person. And then reach was, how far? How far do you go? Inadvertently, a relative of yours, a distant relative of yours becomes a victim of your desire to be a public servant. That was also difficult. But this weekend, I must admit I've had an eureka moment.
You went for a discussion on this.
Yes.
But what you just mentioned, so that we don't leave that part.
Yes.
Verification, publication.
Yes.
The advocacy has also been that if these are not done, you are supposed to declare before you assume office.
Yes.
Then you declare every 4 years.
Yes.
And then when you finish your office, you declare again.
Yes.
Now, say you finish office and you declare. Because it wasn't publicized, nobody knows what you have gotten which you can't explain.
That is where I'm going now.
Okay.
I'm saying that this weekend, and Inusa was there, this weekend we were out of town pre-discussing the conduct of public officers bill before we lay it on the floor. And I've had an eureka moment. Honestly, I must confess that in looking at the new bill, I think it has clarified this question about verification and reach. It has landed it squarely on even compliance with the bare standards that we have. But if we were to comply even with the bare standards that we have, we would indirectly be ensuring verification later. But the biggest problem we have now is compliance. And that is the subject of the two cases that you have had. Because it is assumed that nobody will know whether you did it or not, because it's not published and otherwise, then people really don't bother. And it's voluntary. There is nothing that compels you to file. You understand? The question you asked me, that's where I'm coming. I'm saying, I've had this eureka moment, and I'm thinking that if we can even compel people on pain of some sort of sanction to file, then that commitment alone has put them in a situation where they have to be alert and careful.
All right.
You understand what I'm saying? So for me, those two decisions, and in particular the decision, the G-Mensa decision, is an excellent piece of jurisprudence from the Commission. Excellent piece of jurisprudence. Because the Commission has laid out what we haven't done over the years to give effect to Article 287. Essentially, because 287, in telling them 287.2 says the Commission for Human Rights and Administrative Justice, or the Chief Justice of the case may take action as it considers appropriate. The Commission argues in G-Mensa that action appropriate is administrative sanctions, and that if you criminalize it immediately, you remove the ethical part of integrity, because there are two aspects of integrity in the public space. You know, you have the ethics part, which is not necessarily criminal, more or less preventive, and then the criminal part, which is egregious, malicious, and willful intent. It never goes away. But immediately you criminalize the ethical part ab initio, you've left no room at all for honest mistakes. You've left no room at all.
In this circumstance, the criminal parts will include where you knowingly under-declare or you hide some of what you have to declare.
Yes.
Or you declare something that doesn't exist because you intend to use corrupt means to acquire it.
You knowingly do that.
Okay.
Then the Commission is saying, in the new COPO, for briefness, conduct of public officers, in the new COPO, the Commission is saying that the SHRAJ should have discretion to refer the criminal ones to the Attorney General. But initially, in terms of ensuring compliance, that you will file according to the 3 criteria, before office, during office 4 years, and after you've left, they must have a certain raft of administrative sanctions to ensure that you do that.
Okay.
And how do they do that? They made certain propositions. They've made certain propositions. And I think we must interrogate those propositions exhaustively. Because they are saying, for example, that before you take office as a public officer, and don't forget, this thing is from as low as directors in state institutions.
Right.
You have thousands, literally thousands of people who should declare their assets. If I'm not afraid, I would say maybe in excess of 100,000 officials who must declare their assets to the Auditor General, sealed, and he takes custody. Now, SHRAJ are saying that as part of the administrative sanctions, that they need elaborated pursuant to Article 287,
right,
in order to make sure that their sanctions are, their discretion is clearly stated under the same constitution. They cannot, because of the discretion, they cannot keep it to their chest. Everybody must know the administrative sanctions, but they are suggesting that before taking office, you must produce a receipt of filing, and that receipt, if you don't have it, should disable you
from occupying,
from taking that office that you have.
Even the president, that before he swears the oath,
every public officer must have his receipt in his wallet. Just like you have your Ghana card or your passport. Some people carry their passports in their top pocket around all the time. I don't, but some do. So you must have your receipt handy, so that the moment you are pronounced, Inusa, the outgoing MP, will not be minister again, but when he was minister, Inusa about to become Minister of Roads, produce your receipt. Otherwise, you don't get that office.
Right.
In that case, if you haven't filed, there will be no time to run and go and file and bring a receipt, then you have forfeited the office. There will be no room to now rush to go and file saying that I was too busy, or I forgot, and I wasn't in public office. The thing was thrust upon me suddenly. I didn't expect it. No, you, as soon as you are named, you must be, and potential office holders would also prepare the asset, because you know there are interlocking laws. You have an income tax self-declaration regime, which ought to make you know your assets all the time. Because your income tax regime covers all you own. You understand? So if you are complying with your income tax...
And all the time we talk about asset, and this Auditor General likes us not to forget that there's also liabilities. You're supposed to declare both your assets and your debts, your liabilities.
Correct. So if you were complying with your income tax rules, you will find it so easy. The day you are named as a public officer, within 48 hours, 24 hours, to have your form filled and filed so that you can have a receipt to present on the day you are nominated. If you are not in a position to take office within a week or two with your receipt, or we can have a timeline. By the time you are named, if within a week you don't produce your receipt, and you produce a receipt after you are named, you are out.
And for those the president has to swear in.
For you to speak. Let me land.
And for those the president has to swear in, the president must insist that if you don't show the receipt, I won't swear you in.
You're out.
Okay.
Then they are talking about being deprived of income during the 4 years. That if during the 4 years you don't present proof of refiling, then your income should be detained. Then the most interesting bit is when you leave office.
Exactly.
They are saying that if you leave office,
your benefits,
and you don't file, your benefits should be held on to until you file. You understand? And at that stage, I believe that a comparison can even be made, even though the rules haven't yet reached the level where we are talking publication, or even the question of what disclosure means. Can the Auditor General look at them by himself? The conditions are given, unless there's a problem, and then the secular argument comes. What if there is no problem? How do you determine when there is a problem?
So let me bring in Dr. Kojo Asante. What do you say about the proposals made by Shraj? And if I may go over that quickly, Shraj says one of the effective ways to ensure speedy compliance is to disable relevant public officers from taking office or receiving any emolument or benefits from office until they can show that they have complied with the law, that they have declared. That the new bill should specifically provide that appointing authorities should require proof of declaration of assets and liabilities before appointees are allowed to take office. In the case of elected officials like the President and members of Parliament, the bill should specifically provide that they show evidence of having declared their assets and liabilities before they are sworn into office, since there is sufficient time between when they are elected and when they are sworn into office to comply with Article 2861A. The bill should also specifically provide that elected or appointed public officers to whom Article 286 applies shall not be entitled to any emolument or benefit of office until they have complied accordingly. What do you say about these recommendations?
Yeah, thank you, Samson. Yes, I wanted to be at the committee's meeting in Koforidua, but I couldn't. But we have submitted a memo, drawing the committee's attention to a number of issues currently in the memo. I mean, for example, it's the verification provisions in clause 55 is wholly insufficient. It comes back to the same problem where we're trying to limit it, to when somebody finds out that somebody has breached something. I mean, if you read the Constitution, there is no way in which you can even ask for clarification if there is no verification. So how does the Auditor General ask for clarification? How does the Auditor General know that somebody is knowingly or misleading? And I think when we try to sort of restrict ourselves this way or constrain ourselves we are not helping the process. So I think we really need to look at, how we take this agenda forward. Now, let me deal with the substantive issue that you have raised. First of all, I think we have to make it very clear that, for me, I don't have any problem with administrative sanctions and criminal sanctions cohabiting. If you go through the Public Financial Management Act, there are many, many administrative sanctions that are there. There are also criminal sanctions that apply. And it's for a clear reason. So the reason why, for example, the Kenyan Act only elevates the act of not complying with the act, with the asset declaration regime, and knowingly misleading to the criminal status, tells you that it takes those two issues very, very seriously. It's a public policy matter. So I don't think SRAJ should have any worries, because currently SRAJ doesn't have prosecutorial powers. Even if it investigates corruption, it needs to either refer it to the OSP or the AG. It does not mean that the fact that it doesn't have criminal powers, that means that he should not be able to refer to any criminal sanctions or investigate matters that might actually lead to criminal sanctions. So I think we should have that clear.
In the anti-corruption bodies,
I actually prefer.
Yeah, the CDD. Yeah. The CDD. In your memo, you have an issue with the direction in this new law for the SRAJ to make referral to the Attorney General. You want him to do so to the OSP, and why so? What's the rationale? What are you afraid of?
No, it's just to make it consistent with the law. So as the law currently stands, yes, it refers to the Attorney General, but by the OSP law, there's also another avenue in respect of corruption. So that's what we are just saying, that we shouldn't forget that there's an OSP law that also allows SRAJ to refer criminal cases to. So, okay. But I wanted to say that for me, the two problems we have had over the years is that we don't have enough regulations, particularly to regulate discretion. And we also don't have enough administrative sanctions. So our first port of call is to go to criminal sanctions. And that sometimes is what inhibits people's ability to deal with corruption. If somebody had done something and you say, okay, as SRAJ is proposing, we are basically, you are not going to take your appointment because you have not discharged your asset declaration responsibilities, that person will be forced. If they want to take on the appointment, they will have to do that. And that is really an administrative process. And if you look around the world, that is the process that a lot of people use. And because we don't have regulations around this, that is why it is left to a lot of discretion. So I am sure whether it's the CJ or the EC chair, when you come into office, you don't get a sheet of paper that tells you that all of these things have to be discharged, once you come into office. That should be an administrative procedure that every officer, public officer who comes into office has.
All right.
SRAJ actually proposed ethics officers so that the ethics officer will give you the list of things that you have to discharge before, once you take office. Okay. And I think if we do those things, it would really help us and try to make this
now I wanted to know, because you are unhappy with the outcome in the two cases we are using in reference now, what would you have wished that SRAJ had done, even with the current situation of the power they have within the law? What would you have wished SRAJ should have done to the EC chairperson and the CJ?
Well, it's simple. I think for me, what I don't agree with SRAJ on those two cases is to say that the two people have discharged their responsibilities. They have not, right? So you have to first accept the crime or accept the misconduct, and then say, well, but because maybe you have not shown any actions of this sort in the past, this is your first misconduct. We are basically just warning you. We are giving you a warning. Please don't repeat it again. That's a different judgment from saying, well, the law has not been breached, in effect. And that's where I have a problem. So I think that distinction has to be made, that no, you have not complied with the constitutional obligation, but you don't have a history of not,
doing so.
This behavior, right. And therefore,
all right, so we have heard Kojo Asante, and obviously there's a bit of a problem with his line there. Thank you very much. Hold on, we'll go to the next issue. We'll be going for a break, but before we do that, just a minute each for you to give us your final point of view on this. This particular law, which has been in Parliament, is beginning to behave like the RTI law. It's been in Parliament for such a long time. After the RTI, it's the second longest. What's the problem? Why are you guys not passing it?
Well, the problem is multifaceted. And I disagree in some respects with the submissions of my brother, Bobia Samoa. And I think that where a duty is imposed on a public officer by law, there is an additional duty to comply with that duty.
Okay.
And so, if the law says, as a public officer, you have a duty to ensure that you fill these forms, failure to discharge that duty is an infringement of the law. And so, I agree with Kojo Asante. When you use the discretion given you by the Constitution in such a way as not to exact punishment, it weakens the fundamentals of what you want to do, and that is what is happening. And when you said some people even put, maybe people can even put, I said it to Kofredua, they do everybody almost burst into laughter. You must think outside the box. You must contemplate situations where people can do that. Why? Because if you don't get yourself into problem by the present regime, your asset declaration will not be opened. So people can deceive knowingly. And that is why I believe there must be instances, robust provisions in the law for verification and probable publication.
Okay.
You have elected to be in public office. That means you are prepared to live with the vagaries of public office, of the dictates of public office.
Okay.
Yes, the breach of the law does not necessarily mean criminal law. You can also breach administrative law. You can breach administrative rules. If you persistently come to work late in Joy FM, you can be suspended. Your pay can be withheld. You can be queried. You can be warned. All manner of things. Ultimately, you may even be dismissed. These are all legal processes, but they are not necessarily criminal. So what we are saying is that these provisions have not existed. We have not elaborated them. Shraj is now saying...
Wait. You know that Shraj, the former boss of Shraj, Loretta Lamte,
right.
Richard Nyama took a petition for her removal.
Yes.
I prosecuted that case.
Right.
She committed a breach of the, including of the Rent Act, which said you shouldn't pay 2 years advance for rent.
Right.
She suffered. She left. She was removed from her office. Wait, Charlotte say breaches of procurement law.
Yes.
She lost her office.
Yes. Something.
Electoral Commission breach of the Constitution.
I am saying that we have not elaborated. These instances you are saying have been done in breach of the elaboration. So that we are now about to elaborate, for me, is the most excellent thing that has happened to us. When I began, I said I had an eureka moment. This thing has been lying in Parliament for several years, the conduct of public officers. Perhaps because the parliamentarians may not even have appreciated what's at stake. And I'm saying that now, I realize, as an anti-corruption campaigner, I realize that what's at stake as a first step is ensuring compliance. Compliance cannot be criminalized. Beyond compliance, Then there are the steps about knowingly falsifying and all those things. And they are criminal.
No.
Nobody is saying that.
Nobody is saying that
you can have an exclusive administrative jurisdiction.
Non-compliance can make can render a person unfit for office.
Yeah, but that's administrative.
Yes, it's not administrative.
But
when you go ahead to prosecute, then you become a criminal.
No,
in the law, in section 55, or where was it? There's a particular provision.
Yes.
You are saying that there should be reference to the Attorney General.
Yes, not all.
When it's going to Attorney General, we can anticipate what is going to happen.
But
that's where CDD says, and the Ghana Integrity, the anti-corruption group says, don't limit it to Attorney General.
No.
I know one of the suspicions. If you are in office, Attorney General is a political person, it's a party person. They may not prosecute you because you have breached the law. So if you give it to the OSP, they may prosecute you.
I also have you had your 1 minute.
That, look,
then let's go on with
read
this.
Article 2.
You had your 1 minute. Why am I not getting my 1 minute? You read your. I thought this was my 1 minute.
It does not preclude the commissioner from going to court for a declaration.
Okay, thank you very much.
Look,
we'll take a break here.
That's not fair to me.
Yes,
that's not fair to me.
I gave you a 1 minute.
Nowhere, but he's taking it back. Nowhere have I said that administrative sanctions exclude what do you call it? Criminal sanctions. They are both in the public officers' conduct of. And I'm also saying that the sunshine rules are being expanded on a daily basis, including the OSP.
All right.
Our government has brought in an OSP which has been established. That OSP operates independently of the Attorney General. So we are expanding the place of sunshine. RTI has been passed, and now OCO is going to be passed.
All right.
We are in a good place.
Obviously, what the CDD and other anti-corruption organizations are asking, you will do it in the law.
This is one law that the people of Ghana must get involved in.